Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
We'll bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.
Payment clause.
Okay. When we started the program, I mentioned one of the principles of contract, which is consideration.
Right.
So payment is a consideration in commercial contracts. Whichever way, even if it's a construction contract, a supply contract, or a service contract, payment is a consideration because I offer you my service, you pay me for my services.
Right.
So payment is very, very essential in commercial contracts because that's the reason for the contract. For one party to get service and one party to gain.
Right.
Yes.
Okay. So payment is very essential.
Very essential,
to
yes.
put that in. Okay. Obviously, you know, some other bits of clauses that you put in the contract are very important as well. And most of them is the termination aspect of it because, you know, contracts don't just last till ages.
Yes.
They all have a lifespan.
Yes.
You know, at what stage, what are the terms or how we want to say you've terminated this contract? And what are the consequences of terminating this contract where within enough the agreed term in the contract?
Okay, the consequences of terminating a contract without the agreed terms of the contract is that the party terminating a contract, you have to have a just cause for terminating a contract. If there's no just cause for terminating a contract, the party will have to suffer damages.
Right.
You have to pay damages for terminating a contract. So for a party to terminate a contract, you must make sure that you have the steps, you must take the steps in the contract to terminate the contract. And you must have reasons for termination of the contract.
Right. So if these reasons are not cogent enough, that means that and the other party has gone to terminate it, that becomes a potential problem.
Yes,
right.
Big problem because you need to have reasons for termination. You can't just wake up and say you want to terminate a contract. You must have justifiable reasons for terminating a contract.
What are the types of these terminations? What are the types?
Okay, you can terminate a contract for non-payment, for example. You can terminate a contract for a client who is not performing his obligation under a contract. You can terminate a contract because of suspension of a contract.
Right.
You can terminate a contract because of a force majeure event and unforeseen circumstances.
Right.
So there are different. It depends on the way you draft up your contract and what you want to be as a terminating principle under your contract.
Right. And effectively, at the end of the day, even if one party argues that you've not taken you should have terminated it at this stage, it still boils down to follow the next process before one can remedy that contract. Assuming now it's, as you rightly said, in the friction of time, yes. And the other party feels that if we terminate this contract, it is over. Or the other party feels, no, it's not yet over. We still have done this and done that, which you didn't do. Therefore, the contract still goes on. At that stage, the argument, the stage will be for two parties to agree, isn't it? To decide to carry on the contract to the next stage. What if other party believes, no, it's ended? Your own calculation is wrong. My calculation is right. How do they get it right?
Okay, that's a very interesting comment. What happens in commercial contracts is that you have to be clever when you're drafting your commercial contracts. You put in terms like adjudication,
right,
or arbitration, right? So when you have such impasse, what you need to do, what your contract terms should have stated that if there's a dispute to a particular issue under this contract, the dispute should go to the arbitration.
Right.
While the performance of the contract will be ongoing.
So effectively, yes. Not stopping this.
Not stop, exactly.
Carry on, but let's go and settle
that particular issue. Yes.
Right, I get you there. That's another one. You know, we've also in this program talked about the obligations of parties. Obviously, that means that both parties have agreed on this term, and this is what they are doing. Now, And major area which I wanted to deal with in this program before wrap with this program is about the limitation liability.
Yes.
Because even if in all contracts you see there's some form of limitations. Talk us through limitation liabilities in commercial contracts, because it's very important to put them in there. What does it connote? How is it going to be applied, and how are we going to take through it? Talk us through that.
Okay, limitation liability is a simple contract term which limits the liability of each party in the case of loss or breach of contract.
Right.
For example, like I explained before, if you have a contract for £10,000 and there are no exclusions to the contract, because when you have exclusion, you have to exclude consequential losses.
Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
We'll bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.